Legislative Relations, Articles 245 to 255 of the Indian Constitution. Introduction. Legislative relations explain how lawmaking powers are divided between the Union, central government, and the states in India. India follows a federal system, but the Constitution gives more power to the Union to maintain unity. Articles 245 to 255 deal with this distribution of legislative powers. Article 245, Extent of laws made by Parliament and state legislatures. Parliament can make laws for the whole of India, or any part of India. State legislature can make laws for the whole of state, or any part of the state. A law made by Parliament cannot be invalid only because it applies outside India. In short, Parliament has wider legislative powers, while state legislatures have limited powers to make laws for their respective territories. Parliament has overriding power in certain matters, especially on subjects mentioned in the Union List and Concurrent List. In case of conflict between a central law and a state law on a concurrent list subject, the central law prevails. The opinion of states is generally advisory in nature and is not binding on Parliament, except in special cases where the Constitution requires state consent. A law made by Parliament is passed after approval by both the Lok Sabha and the Rajya Sabha and becomes effective after receiving the President's assent. Similarly, a state law is passed by the State Legislative Assembly and the Legislative Council, where it exists, and becomes effective after receiving the Governor's assent. Article 246, Distribution of Legislative Powers. Article 246 divides subjects into 3 lists under the 7th Schedule. Union List, List I. State List, List II. Concurrent List, List III.